morning, Ms. Ford.
Good morning, my Lord. I'm going to briefly work through the passages of the cross-examination that the CMA rely on, and then I'm going to turn to the point about the extent of the tribunal's merits jurisdiction. I'm hoping I can take this...
Hang on a second, I think you could just let my Lord... Sorry. Right, yes. Start again, please.
My Lord, I was proposing to briefly work through the passages of the cross-examination that the CMA rely on, and then to turn to the point about the tribunal's merits jurisdiction. And I'm hoping that I can take, in particular, this first part relatively swiftly, because, in a way, it's simply drawing together threads of matters that were canvassed on Friday. Our submission would be that the CMA has not put a case that is sufficient as a matter of law or fact to amount to an agreement not to enter the market. Starting with the first email in Mr. Turner's table, the email of the 19th of April 2014, the court will recall this is the email in which Mr. Baton says he's not keen on getting into a battle about the skinny label status of his products, and he anticipated that Mr. Patel was not keen either. This is the email the CMA relies on to contend that AMCO and Auden preferred a supply agreement to the risks of market entry. And the cross-examination on this, I'm going to work through the cross-examination essentially in order. So we're in tab 7.
Where's the email?
The email is behind Mr. Turner's table. It's not actually in the bundle, but it is in the hand-up that Mr. Turner provided.
What, the contemporaneous document? What's the date of it?
It's the 19th of April.
19th of
April, my Lord.
19th.
And Mr. Turner handed up this clip of documents, and it's behind that. Page 3 in his clip.
Yes, this is an interesting one.
This is one of the ones the CMA has relied on. The cross-examination on it is behind tab 7. It starts at internal page 4, but the key passage is internal page 7 in the cross-examination. And we see lines 12 to 14, where it's first put to Mr. Baton, you understood the risks of your own product versus the supply agreement.
You've got to give me the page of the cross-examination again.
It's 528 in the supplemental bundle, internal page 7.
Yeah.
And it's put to Mr. Baton, you understood the risks of your own product versus the supply agreement, yes, and then he agrees. In our submission, the most that's being put there is that Mr. Baton had a unilateral preference to take supply rather than run the risk of going to market with a skinny label product. And so we say, what is not being put there is any sort of commitment or agreement not to enter. We then see it being put, you understood that Amit Patel's perspective was either he gets into a battle with you about the orphan drug designation if you launched, or he might offer you better supply terms on that. And again, I'll come to Mr. Baton's answer, but that was what was put in respect of Mr. Patel. And in our submission, again, what is being put is Mr. Patel's unilateral perspective. What is not being put is any sort of commitment or agreement between Mr. Baton and Mr. Patel. And then we see what Mr. Baton says in response. He says, I was hoping, always hoping, that he would offer me better supply terms to us. And that, in my submission, is a classic example of an ICI-type unilateral conduct. Mr. Baton is adjusting his own behaviour in the market in the hope that a competitor will respond in a particular way. We say it is not an agreement. We then turn to the second email in Mr. Turner's table. This is an email of the 28th of May 2014. It's another one that wasn't originally in the bundle. This is one in which Mr. Baton is asking for 12,000 packs from Auden. And if we turn on within the cross-examination bundle to internal page 17, bundle page 538, we can see the cross-examination on this, beginning internal page 17, line 17. And essentially, what is being established with Mr. Baton in this passage is that 12,000 packs was what Mr. Baton hoped to achieve with his skinny label product. Now, much was made of the fact that this was providing sensitive information to a competitor, but that in our submission is a red herring, because this is not a case in which it's alleged that there was an unlawful information exchange. This is a case in which the CMA accepts that it has to show an agreement. And it's unsurprising in the context of a supply agreement that one sees a discussion of volumes. But more importantly, again, in our submission, nothing about this exchange is putting any sort of commitment not to enter the market. We then come on to the premise for the negotiation. This is, we turn on to internal page 26, bundle page 547.
Sorry, you're in the cross-examination at 546.
547, my lord, yes. Internal page 26.
And what are we looking at here? Is this more cross-examination about the 28th of May email?
This is the point at which the CMA puts what it describes, what it eventually described to the tribunal as its more modest case. So this is the proposition that they put. The premise for a negotiation like this is that if Auden agrees to supply AMCO, then AMCO will not enter the market with its own product. And this is essentially encapsulating what the CMA described as its case, and it described it as a more modest case in contrast to the case that the tribunal was seeking to essentially put to it that it should be put in.
Well, Mr. Mitri was putting to him what Mr. Clark had said to the CMA in an interview.
My lord, yes, that's the context of this page.
You pick that up from line 12 on the previous page.
And our submission, my lord, is that this is not sufficient as a matter of law to establish an infringement. And the reason we say that is that it's not a necessary part of this premise that's being put to the witness that he is agreeing or committing to Mr. Patel that he will not come on the market with his own product. What is being put here in our submission is equally consistent with a statement of the practical reality that if Mr. Baton obtains his supplies from Auden, then he need not obtain supplies from an alternative source. And Mr. Baton is agreeing. He's saying, yes, that's the premise. If I get it from Auden, then I don't need to get it from elsewhere. But I ask rhetorically, is he offering any sort of commitment that that state of affairs will continue? In my submission, he is not. And it's not being put to him that he is. And what the CMA doesn't go back and do is try and clarify this ambiguity. They don't put to him that the premise that they're talking about is not just a question of practicality. It's not just you don't need supply from two places. It's that you and Mr. Patel understood that you were making some sort of promise or commitment not to enter the market with your own product. My lords, in my submission, that is a fundamental ambiguity at the heart of the issue, and it was not taken anywhere near far enough with the witness. And that is the conclusion the tribunal also reached in the passage we saw last week at paragraphs 110 and 111 of Hydrocortisone 3. My lords, we then come...
He is agreeing here that the whole premise of the negotiation was that if AMCO agrees, if Auden agrees to supply AMCO will not enter the market with its own.
My lord, yes.
And what he says is, yes, I agree that, but I'm not saying that to him. And that was the point I put to you on Friday. And that's effectively a weaselly way of saying, yes, that's what we were up to, but I never actually said anything. But I mean, the point that's being made is that this was the basis of the discussion. If you supply us, we will not enter the market. Now, why isn't that a promise?
Because, my lord, it's equally consistent with a premise that he will not enter the market with his own product because he already has supply from Auden, which is an entirely neutral and non-offending state of affairs.
Yeah,
the CMA doesn't...
If you do this, then if you supply us, then we will not enter. That's not saying I've already got supply, so I don't need to enter.
My lord, in my submission, it goes no further than saying I don't need supplies from two places at once. If you supply me, I don't need to come onto the market with another source of supply.
I hear what you say. Okay, so that's that one.
That's that one. We then have the significance of the threat to come onto the market. So if we look, please, within the same bundle, pages, internal page 27, so it's over the page.
Yeah.
This is where we start to discuss the bluff. And we see 23 to 25. You were telling him that if you did not do this supply deal, you would come onto the market and you would contest 100% of the market, which is what Mr. Clark is saying, to which his response is, I do not think I ever told him that, but clearly that was the implication of this. And the court has my submission from last week that using the threat of entry to try and obtain better supply terms is a unilateral strategy on the part of AMCO. It doesn't entail any understanding or commitment or promise not to enter. We also touched upon Mr. Turner's submission, which was that threatening to enter the market is the manifestation of the wish to achieve an anti-competitive goal jointly, and that's essentially paraphrasing the tested buyer that my Lord Justice Green was drawing attention to last week. In my submission, it is not possible to construe a threat to enter the market, which is in principle pro-competitive, as an invitation to enter an anti-competitive agreement. Our submission is that threatening to self-supply and enter the market independently is a recognised and standard negotiating tactic. And we have, I hope the court has received, 2 documents that we've provided over the weekend that seek to make good that point. The first one was an Oxera report, an extract from an Oxera report from 2001. We do have hard copies available if anybody doesn't have them, but I'm hoping the court may have received it electronically.
Well, I'd quite like to have it in a hard copy. My clerk did not photocopy it.
We will give your lordship 2 documents. The first is the Oxera report, and the second is a Commission guidelines on the assessment of horizontal mergers.
Thank you.
So the first document your lordship should have is an extract from Fundamental Review of the Generic Drugs Market, a report prepared by Oxera on behalf of the Department of Health, July 2001. The passage we relied on, and it's a passage that was cited at footnote 71 of Sinvan's skeleton argument, is the 5th paragraph down on this page. And if the court looks part way down the 5th paragraph, beginning "this is" towards the right-hand side, what Oxera says is that the ownership of a licence for a particular drug increases the leverage for that manufacturer negotiating the price for supply from a rival manufacturer. The ability to self-supply a drug is the most effective and credible threat with which to negotiate supply terms from another manufacturer. Without a product licence, the firm seeking supply would need another potential source of the product, or it would be unable to negotiate the best terms from a supplier. As described in Phase 1, cross-supply arrangements of this sort between manufacturers are very common in the UK generics market. What this is showing in my submission is that this sort of exchange that the CMA places a lot of emphasis on, where the firm seeks supply and threatens to self-supply to get better supply terms, is both well recognised and it's standard practice.
This is July 2001, almost 23 years ago. Is it still recognised as normal, acceptable practice?
Well, my lord, we are talking about the time with which this infringement is concerned.
But the infringement decision itself applied the law some 20 plus years later.
My lord, yes. Nobody has so far suggested that things have changed. Is the highest I can put it.
I mean, this may describe a commercial practice which is prevalent.
And of course, we are talking about a commercial practice which was going on at the time of the infringement. We have also provided a second document to make good the point that it's not just the generics market where this takes place, and this is a later document that may assist my Lord Justice Green's inquiry. It's the Commission's guidelines on the assessment of horizontal mergers, and this is the passage where the Commission considers countervailing buyer power on the part of customers. And we point to paragraph 65 within this document where the Commission says one source of countervailing buyer power would be if a customer could credibly threaten to resort within a reasonable time frame to alternative sources of supply should the supplier decide to increase prices or to otherwise deteriorate quality or the conditions of delivery. This would be the case if the buyer could immediately switch to the other suppliers, credibly threaten to vertically integrate into the upstream market, or to sponsor upstream expansion or entry, for instance, by persuading a potential entrant to enter by committing to placing large orders with this company.
That's normally in a vertical situation. We had this in the Cerelia case a few months back, where you have a customer says, I need to control you, my upstream supplier, and one of the ways I do that is by credibly moving to a rival or initiating or encouraging the entry of a rival to create competitive tension upstream. It's normally vertical, isn't it, not horizontal?
Well, I know the practice, what Mr. Baton had as his alternative was to obtain supply from Ithaca on a contract manufacturing basis, and that is upstream, essentially. That is analogous to upstream integration, and he can do that in the way that the Commission contemplates to seek to exert some form of countervailing buyer power and get better terms. So our submission is what the Commission's identifying is a threat to self-supply as one of the recognised means by which customers negotiate.
Yeah.
And the submission we make is it's not sufficient to point to something which is both ubiquitous and innocuous, and to seek to characterise it as an invitation to collude. And the court has the point that the tribunal also considered this exchange in Hydrocortisone 3, paragraphs 112 to 114, and it wasn't satisfied that this was sufficient. Finally, I'm coming to the 15th of June 2014 email, and this is what the CMA considers to be the high point of its case. It's the email where Mr. Baton says, I told him that if not, we will launch our own. And that's also in Mr. Turner's bundle. Mr. Bruley addressed you on the factual context of this. It's external counsel for Auden sending the draft second written agreement to Mr. Sully of AMCO. Mr. Sully is forwarding it to various people, including Mr. Baton, and the query he's directing at Mr. Baton is whether the delivery date under the second written agreement should be June or July. Mr. Baton has given evidence about this exchange in his witness statement. And I'd like to ask the court please to just read it very quickly. It's Supplemental Bundle, tab 1 at page 32. And in particular, paragraph 87, please.
Paragraph
87. So he is here explaining that the exchange that we're focused on is essentially concerned with timing of delivery under the second written agreement. And he was cross-examined on that within his transcript, internal page 29, bundle page 550. Beginning line 18 to 21, where it puts him what you told Amit Patel, we see here, is that if he did not start supplying you with the 10 milligram tablets that month in June, you would launch your own product. To which he replied, yes. Now, just pausing here, the court will recall that that's exactly what the second written agreement entitles him to do on notice. Lines 24 to 25, it's then put to him, and the new 2-year deal was signed on the 25th of June, was it not, about a week after this email exchange? That question, in my submission, it's clearly relating to the second written agreement, rather than any unlawful agreement. He's been asking about a 2-year deal signed on the 25th of June. So that is the second written agreement. And then over the page on page 551, we see at line 2, again, both you and Mr. Patel understood Auden was doing this deal because if it did not, Amco would launch its own product. Now, what does Mr. Baton understand by the reference to this deal? In my submission, it can only be a reference to the second written agreement, which he has just agreed. He's just been asked about, he's just agreed, it was signed a week later. So what's being put to him is that both parties understood that Auden was entering into the second written agreement because if not, Amco would launch its own product. Nothing there about any additional unlawful agreement. Lines 12 to 16, we then see it put to him, you said it expressly to him, yes, even though you would say you were bluffing, that is what you told him. You said, if we do not get this over the line, we will launch our own product, to which he said, it looks like I said that, yes. What does he understand by getting this over the line? In my submission, in this context, that can only be a reference to the second written agreement. And so, in our submission, this falls a long way short of putting a case that you and Mr. Patel shared a common understanding that you were agreeing not to enter with your own product, or you committed to Mr. Patel that you would not enter with your own product. It doesn't put to Mr. Baton that he was agreeing not to enter at all. It puts the opposite, that Mr. Baton had expressly threatened to enter. And an express threat to enter in our submission simply doesn't equate to an agreement not to do so. That threat to enter is made in the context of a written agreement which permits him to enter. And so why, when he's permitted to enter, should his threat to enter be understood as meaning exactly the opposite? And in our submission, it would be unfair to Mr. Baton to treat this as any sort of concession that he was engaging in a pay-for-delay agreement, because what he understands he is answering questions about is the second written agreement. And no one has put to him that by this exchange he was making a different and additional commitment to Mr. Patel that he would not enter with his own product. So, my lords, that is our position in response to the CMA's appeal, and I'm moving on to issue 4A, which is the point we canvassed to a certain degree last week, that the CAT's Hydrocortisone 2 judgment has exceeded the scope of its merits jurisdiction. Starting with the applicable principles, I ask the court please to take up the first authorities bundle and the relevant provisions of the Competition Act behind authorities bundle tab 3 at page 22. Starting with section 46(1), any party to an agreement in respect of which the CMA has made a decision may appeal to the tribunal against or with respect to the decision. Subparagraph 46(3) defines decision to include a decision of the CMA as to whether there has been an infringement of either the Chapter 1 prohibition or the Chapter 2 prohibition. And we see 46 subparagraph 5 provides that Part 1 of Schedule 8 makes further provision about appeals. So just turning to that, that is page 39 within this bundle. And paragraph 3(1) of Schedule 8 provides that the tribunal must determine the appeal on the merits by reference to the grounds of appeal set out in the notice of appeal. So the boundaries of an appeal on the merits are delineated on the one hand by the content of the decision, and on the other hand by the grounds of appeal set out in the notice of appeal. The CMA's position as to whether there has been an infringement is fixed by reference to the contents of the decision. We can see that from the case of NAP, which is in Authorities Bundle tab 12 at page 213. Starting at paragraph 76, we can see that the tribunal observes that the appellant is not limited to placing before this tribunal the evidence he has placed before the director, but may expand, enlarge upon, or indeed abandon that evidence and present a new case. It then goes on to contrast that in 77. It says, we doubt, however, whether exactly the same liberal approach to the submission of new evidence can be applied to the director. In our view, the exercise of the discretion to allow new evidence by the director at the appeal stage should take strongly into account the principle the director should normally be prepared to defend the decision on the basis of the material before him when he took that decision. It is particularly important that the director's decision should not be seen as something that can be elaborated on, embroidered, or adapted at will once the matter reaches the tribunal. It is a final administrative act with important legal consequences, which in principle fixes the director's position. In our view, further investigations after the decision of primary facts in an attempt to strengthen by better evidence a decision already taken should not in general be countenanced.
It wasn't drafted in the absolute, was it? It's a general proposition. As I recollect, looking at the case, trying to scratch my memory from 23 years ago, the DG, Sir John Vickers, completely changed the case in front of the cat and tried to run a case which wasn't in the decision. And the President held, no, you're stuck to your decision, but we uphold it.
My Lord, yes, and your Lordship would appreciate what we say is a clear parallel with what the Tribunal has done in Hydrocortisone 2. And in our submission, if it's right that the CMA is fixed with the position as it is in the decision, and it's not permitted to elaborate on it or embroider it or adapt it or strengthen it, then in our submission, exactly the same must apply to the Tribunal itself.
Can I just ask you, in NAP, there was a fundamentally different theory of the case advanced on appeal by then the Office of Fair Trading, the DGFT. Is that different to a case in which the CMA's basic thrust, its analytical thrust, remains the same, but the evidence changes simply because you have witnesses who are cross-examined and new evidence comes out? To what extent is the CMA bound by exactly the same evidence when by very nature of the process we're talking about an appeal which is essentially a trial? So there is new evidence.
My Lord, I accept that within the broad bounds of the decision, there's a degree of scope for debate. However, your Lordship put it to me that the CMA's case might have changed. In fact, the CMA's case is that they haven't changed their case. They have not sought to adopt what the Tribunal has done. They have sought to disown it. So this is a slightly different case from one where the CMA embroiders. And in our submission, a fortiori, the Tribunal should not be purporting to embroider a final administrative act in the way that it has done.
But again, the answer to your question is on the following page, paragraph 81.
I'm grateful to Mr. Turner. We'll see in Burgess, which is a case that I'm going to come on to. The fairness of the procedure is one of the factors that the Tribunal identifies as constraining the circumstances in which one can deviate from the scope of the decision. And our submission will be that in a case such as this, where neither the CMA nor the appellants have sought to put forward a case and the Tribunal has instead advanced its own case, that is a classic scenario where fairness precludes that from taking place, where fairness suggests that it is outside the scope of an appeal on the merits. This court has confirmed that the scope of the Tribunal's merits jurisdiction is indeed tethered to the contents of a decision, and that is my Lord Justice Green's judgment in Flynn Pfizer, Authorities Bundle tab 49, at page 1924.
Sorry, tab.
Tab 49, page 1924. If we start, please, with paragraph 135. This is referring to the fact that the CMA has a margin of appreciation in the sense that the legal test for an infringement confers a significant latitude upon a competition authority as to the methods and evidence bases that it resorts to in order to prove the infringement. And 136 explains that the significance of the tribunal's merits jurisdiction is that it is not obliged to pay deference to the competition authority's exercise of judgment. And so we see this is third line, under the Competition Act 1998, the tribunal has a merits jurisdiction as to both law and fact, and upon the basis of established case law, it's not bound to defer to the judgment call of the competition authority. It is empowered under the legislation to come to its own conclusions on issues of disputed fact and law and can hear fresh evidence. Now, it's important to emphasise exactly why the tribunal is permitted to depart from the findings of the competition authority. It is intended to be a safeguard for the appellants to ensure respect for their Article 6 rights to a fair trial, which are not sufficiently guaranteed at the administrative stage. So the tribunal needs to be able to take into account fresh evidence placed before it by appellants and reach its own factual conclusions, and that's what's explained in the following paragraph. The continuation of the same paragraph. It says the conferral, this is just opposite J, the conferral of a merits jurisdiction upon the tribunal flows from important legal considerations relating to the rights of defence and access to a court, and the fundamental rights such as Article 6 of the European Convention on Human Rights. The starting point is that competition law is treated as a species of criminal law. There's a wealth of case law establishing this. And if we go over the page, opposite B, one of the cases cited is Argos. This is on an appeal in relation to alleged price fixing. The Court of Appeal recognised the necessary connection between a full merits hearing and Article 6. The appeals to the tribunal in the present cases were in effect 4 hearings with such relevant evidence as any party wished to adduce, witnesses being cross-examined if appropriate, that is necessary so as to ensure that Article 6 of the European Convention is satisfied. So, just pausing there, in our submission, it would be surprising if the tribunal's merits jurisdiction, which is intended to protect appellants and ensure that their Article 6 rights are protected, could be used to their material detriment. And in our submission, that means it should not be used to find against them an infringement on a basis which is not advocated by the competition authority itself and on a basis which they've not attended the trial prepared to address. Paragraph 141 then sets out the limits of the tribunal's merits jurisdiction. And it says, notwithstanding the above, the jurisdiction of the tribunal is not unfettered. This flows primarily from the fact that the appeal is not a de novo hearing, but takes the decision as its starting, middle and end point. Under section 46, the appeal is against or with respect to the decision and includes whether there has been an infringement. That focuses upon the impugned decision. That focus upon the impugned decision is reflected in the procedural rules of the tribunal. The appellant must identify the decision under appeal and set out why it's in error. Grounds must set out the extent to which the decision is based on an error of fact or was wrong in law. Those provisions are the ones that I have already shown the court.
Can you just remind me, at the end of the day, if the CAT can the CAT take its own decision and substitute its own decision on an appeal for that of the... So prima facie is deciding decisions good, bad or indifferent.
Manuel, yes.
But in extremis it can say the evidence, let us say hypothetically, is so different that we can impose our own decision.
Within the confines, in my submission, of the merits jurisdiction. So yes, it has that power, but in my submission, what one sees from the legal provision that your Lordship cited in this paragraph is that the tribunal's jurisdiction to do that is bounded, and it is bounded on one side by the contents of the decision and on the other side by the grounds of appeal. And within that, yes, it can.
I don't think we've had to explore that in the case yet, have we?
Not that I'm aware of. No. It is somewhat novel. We do have one other authority that touches on it, which is the Burgess case that I mentioned earlier. It's Authorities Bundle tab 20. Page 907. This is an extract from the case, which itself is substantially longer. But what this was an appeal against a negative finding by the competition authority, so a finding that there had been no abuse of a dominant position, and the appellant was inviting the tribunal to use its powers to make all the necessary findings of dominance and abuse in order to establish that there had been an infringement of the Chapter 2 prohibition, rather than remit the matter back to the OFT. So there is in our submission a relevant distinction that one has to bear in mind here, which is that the appellant, in the context of its grounds of appeal, was putting material before the tribunal and it was inviting it to make a finding of infringement. Whereas, as the court will appreciate, in the present proceedings, no party was placing material before the tribunal and inviting it to take the course that it in due course did. But what we see is the tribunal articulating its understanding of the circumstances where it would be appropriate for it to take its own decision rather than to remit the matter to the OFT. And this is 131 and 132. On the specific question that now arises, whether to remit or decide, the tribunal said in free serve, everything will depend on what is necessary to meet the justice of the individual case, bearing in mind both the overriding need for fairness and the need for expedition and saving costs. In our judgment, on the above basis, the tribunal should, if necessary, take its own decision rather than remit if 1. It has or can obtain all the necessary material, 2. The requirements of procedural fairness are respected. The court would appreciate that accords with the passage that Mr. Turner stood to highlight. And then the course the tribunal proposes to take is desirable from the point of view of the need for expedition and saving costs. Such an approach, in our view, is compatible with the overrunning objective of deciding cases justly. In our submission, the way in which the tribunal dealt with the common understanding point on the facts of this case, and by that I mean that it inferred an express conversation between Mr. Baton and Mr. Patel, and that express conversation included not only an agreement that AMCO would not enter the market, but a price-fixing element, was simply not open to it on its merit jurisdiction. We say that contrary to the first requirement identified in Burgess, the tribunal didn't have the necessary material to draw the inference that it did. And contrary to the second requirement in Burgess, the requirements of procedural fairness have not been respected. No part of the case that the tribunal found was actually put to the witnesses. And that is common ground because, of course, the CMA says that was not our case.
And your criticism in this respect really focuses on the one paragraph in H2.
My Lord, yes,
Just
it's
trying to-
page 483.
Yes, it's para 144.8.
Subparagraph 8. Yes.
Yeah, 144.8,
My Lord,
internal
yes.
page 88. That was the paragraph.
It is. And the court,
And that's the only paragraph you say in which they've overstepped the mark unlawfully?
well, I think it's important to appreciate that this is the culmination of the entire series of reasoning which begins back in 92. And this slightly relates to the point that I canvassed with my Lord Justice Flo about the fact that they look at unilateral matters. They work their way up to it. But the way in which they resolve this core dispute about was there a communication which crossed the line culminates in this paragraph. And we can see how important it is because we see, for example, at 145, we therefore, so immediately afterwards, on this basis, we affirm the conclusion reached in the Hydrocortisone decision.
This is an inference, they describe it as an inference. It's an inference of fact.
Yes.
And it's based upon the evidence which was tendered in the course of the appeal.
It's based on the documentary evidence, which you should appreciate the dynamic, that the tribunal first in H2 looked at what it could see on the documents and then in H3 expressed its concerns about the extent to which matters have been put to the witnesses.
Well, it's not based solely on the documents, it's based also upon their assessment of the evidence of Mr. Bacon. Subparagraph 5 in the same paragraph, for example, which we looked at last week, the commercially imbecilic point.
My Lord, yes, but it's not the entire picture because what the tribunal then goes on in H3 to do is consider whether or not the finding it has made can be upheld in the light of what was put to this debate.
Well, never mind that, but I mean what we're looking at the moment is whether they've, as my lord put it, overstepped the mark in H2. And I'm simply putting to you that I'm not sure it's right to say that it's simply based on the documents. It's based on the evidence as a whole.
It may be that I can't dispute, my lord, that there's a reference to Mr. Bateman in subparagraph 5, but in terms of the dynamic as between the two judgments, what one sees is a provisional conclusion expressed in the light of the tribunal's review pending its views on the witnesses, and then that being revisited in the light of its concerns about whether matters were put to Mr. Bateman. And on any view, this finding was absolutely not put to Mr. Bateman.
Would it be unfair of us to take into account that Mr. Bateman accepted in cross-examination that he had conversations with Mr. Patel?
My lord, one certainly can't deny that they had conversations, but insofar as one seeks to place any weight on that, that cannot suffice to establish an express conversation with the core content that establishes an infringement. It's absolutely self-evident that they had conversations. In my submission, one simply can't infer from that the case is made out on that crucial element of this infringement. And of course, the tribunal is well aware they had conversations. That's the point it makes in Little Roman 1. It says there was an opportunity to do this, but this was not the CMA's case. This was not put to Mr. Bateman. In our submission, it falls outside the scope of an appeal on the merits, and it cannot stand. My lords, I'm moving on to my final point, which is the question of the duration of any common understanding post-May 2015. And the point is this: even if there was, or were to be, a basis to infer that a common understanding arose between Mr. Bateman and Mr. Patel, in our submission the tribunal was wrong to find that any such common understanding persisted, and so the infringement persisted beyond 29th of May 2015, which is the date when Mr. Patel left Auden. And we say, or at the very latest, 1st of September 2015, which is when Auden's business transferred to Actavis UK. Now, to see why we say that is, can we please look at the decision for tab 11. At page 535. What the court should have there is figure 3.1, corporate history of Auden Actavis. The position on the left-hand side of the dotted line in this table is the position prior to 29th of May 2015, and the position on the right-hand side is the position after acquisition by Actavis plc, which was then renamed Allergan Plc. Now, we've shown the Court of Appeal the authority that the corporate entity has no mind of its own, and so it can only act through individuals. And what that means for any common understanding in our submission is that common understanding must exist and subsist in the mind of a natural person. And so if that natural person departs, then the company has no means by which any such common understanding can continue. So if we go back to this diagram, if we assume in the CMA's favour that Mr. Patel had the requisite common understanding, he's part of the Auden-Mackenzie undertaking on the left-hand side, and so that undertaking can be said to have the requisite mental state while he is present. But once he has left, the undertaking no longer has an individual by which it can possess the relevant state of mind. And so, in our submission, any common understanding ceases as at May 2015.
Even if the undertaking as a corporate entity continues to comply with the terms of the prior arrangement?
My lord, yes, because there is a relevant distinction between continuing an infringement which is shown to exist, and the question whether that infringement exists at all and continues at all in that period. And that's when I'm going to come on to remind the court about paragraph 7.7, but that's when the CMA itself says these agreements continued for as long as the common understanding existed between the relevant parties.
So Mr. Smith, who owns a company, enters into a price-fixing agreement with his rivals. He sells the company half, and they fix the price at X, which is super competitive. He sells the company and he departs, and the company then continues to apply X for the next 10 years at a super competitive level. The company's not engaged in price fixing.
Well, the first point is the infringement that the CMA has found in this case is somewhat unique in turning on an unwritten and, on their case, unspoken common understanding. If that common understanding is not held in the mind of an individual, then yes, the company will not continue to infringe, because that essential element is not present. Now, if one could show as a matter of fact that the company was aware of the infringement, and we're going to come on to show there was a case that the tribunal cited which bears more on your lordship's facts, the company was aware of the infringement and continued it after the departure of the individual concerned, then yes, of course it continues the price fix. But in the circumstances of this particular infringement, where everything turns on whether there was this common understanding that AMCO would not enter the market, if there's no individual that holds that common understanding, there can be no infringement.
So if it's all recorded in the minutes of a private meeting, but the new executive team just don't bother to read those minutes, yet they continue to supply at the super competitive price, on your analysis there's no infringement.
Well, my lord, that's not quite on a par with the facts of this case.
In principle then, you would say, no, there's no longer an infringement, even though the price is still super competitive.
One has to ask whether the infringement that your lordship is talking about is one which can only exist when a common understanding continues.
Okay.
But that's the first.
So we're not talking about an effects-based agreement here, we're talking about an object-based agreement only.
Well, it would have to be a particular type of objects-based agreement, because of course if one has an objects-based agreement that's based entirely on a written document, which is not this case, then that written document remains essentially implemented by the undertaking concerned, that infringement continues. What we have here is a case that there is a written document plus an unwritten common understanding that is held in the mind of individuals. And our submission is, in that particular circumstance, in the light of the case that's put, that simply can't continue when the individual has gone. But to put our alternative case, which does meet your lordship's point as well, even if there were some mechanism by which one attributes that common understanding to the corporate entity in the way that your lordship is positing, that state of affairs cannot continue on the facts of this case past, I think it's September 2015, sale of the business. And so if your lordship looks back at this diagram, you'll see at the bottom, this is now the right-hand side of the line, so post 29th of May 2015, we've got AM Pharma, and Audren's Hydrocortisone tablets business is transferred to Actavis UK. But it is only the business that is transferred. No corporate entity is transferred. So even if, as your lordship is positing to me, there is some means by which one can say the corporate entity held the common understanding in the absence of a human actor, no corporate entity transfers, and so in our submission there's simply no mechanism by which this common understanding can continue into the Actavis period. Now,
that's brilliant and ingenious.
And in my submission it must be right. And we would say that the CMA has essentially accepted that in its decision. What I'm referring to is paragraph 7.7, 1185. Paragraph 7.7. In this case, the CMA has found two anti-competitive agreements, each lasting for as long as the common understanding existed between the relevant parties. That, in my submission, is an acknowledgement of the fact that in order for the infringement to continue, the common understanding must continue. What the decision did is it tried to find a factual basis, similar to the point your lordship was putting to me, a factual basis on which to say that the meeting of minds continued on the part of Auden after 29th of May 2015, and we can see that within the decision at page 1126. 1126, my lord. Your Lordship should see on that page there's a heading May 2015 onwards. The 10 milligram agreement continues under Allergan's ownership. And just to summarise, the decision makes 3 points. 6.759 to 6.761 are making the point that the parties continue to implement the terms of the not unlawful second written agreement. Paragraph 6.762 is placing reliance on something that Mr. Wilson of Actavis said in interview. And paragraphs 6.763 to 6.767 are making an allegation that a similar arrangement was entered into with another entity called Alyssa. And just to pick up at page 1178, please. There is a section of the decision where the CMA is dealing with the parties' subjective intentions. And the court will see the heading D, Auden Actavis. And if the court could look under that, please, at subparagraph G, we see the allegation that Actavis continued the approach of Auden. Not only did Actavis continue making payments to AMCO under the 10 milligram agreement and implement its own communications plan, drawing on the Project Guardian materials, it also attempted to agree a similar deal with another competitor, Alyssa. Although Alyssa ultimately did not accept this offer, this demonstrates that having taken on Auden's business, Actavis continued Auden's strategy of attempting to buy off the competition on hydrocortisone tablets. So that was the factual position that the CMA found. The tribunal dismissed the CMA's case on the facts. We can see that hydrocortisone 2, page 478 of paragraph 137.
Which paragraph?
Paragraph 137. What we have here is, first of all, a very clear statement of fact. The tribunal says, we do not consider that any of the later entities acquiring the holder of the Merck Sharp and Dome MA did know intention or should have known negligence of the illegal aspects of the 10 milligram agreement. And then subparagraph 1 expressly addresses the state of mind of Actavis. And the court will note footnote 174 cross refers to the hydrocortisone decision paragraph 6.931G, which is the paragraph that I've just shown the court. And it says, we note that the hydrocortisone decision does suggest that there was a guilty state of mind on the part at least of Actavis. Although it is true that Actavis carried on the commercial approach of Auden, we do not consider that this is sufficient to form a guilty state of mind. Although we note the reference and attempt to buy off Alyssa, we were not taken to any of the relevant material. It would be inappropriate to affirm a conclusion of negligent or intentional infringement on the part of successors to Auden on the basis of their individual subjective state of mind. We accept, of course, that the first written agreement and the second written agreement would have been susceptible of discovery, and may even have been known about. But we have seen no evidence of this, and although, if inquiry had been made, the remarkable features of these agreements would have been easily discernible, in the scheme of things, the supply of AMCO of hydrocortisone was small, given the overall market share held by Auden. We do not consider that any later acquirer of Auden can be criticised for failing to appreciate that there was an improper agreement between Auden and AMCO. So the CMA's factual case on this has been considered and dismissed. And I will address the substance if necessary in reply, but we do say the difficulty the CMA faces is that it would be seeking to go behind the express findings of fact on the part of the tribunal. What the tribunal did was to try and approach things from a different angle.
Just before you go on to that, I'm just coming back to 6929 of the decision, 6930, which I don't think in principle is in dispute. But the CMA say parties' subjective intentions are not necessarily an element in the assessment of whether the agreement was restrictive of competition, but they may be taken account of as corroboration, and then they cite a number of reasonably well-known court cases, you're focusing upon subjective intention not only as critical, but must continue as critical.
My Lord, the reason I'm focusing on it is because I am seeking to show that insofar as the CMA's answer to this question of how the common understanding continued was to look at subjective knowledge or intention, and I showed your Lordship that the subparagraph G is itself essentially repeating points that had already been made earlier in the decision. Insofar as the CMA seeks to rely on those points to resist our appeal, we say that's been dismissed as a matter of fact by the tribunal, and it's not open to the CMA to go behind this finding of fact. So, what did the tribunal do? We go, please, within Hydrocortisone 2 to starting at paragraph 99, please. The court will see the heading Unit of Account and Communications between Undertakings. 99 sees what is now a familiar recognition that cartel infringements involve understandings between undertakings, and in order for there to be such understandings, they must cross the line from one undertaking to another. What's being added here is that we're now talking about undertakings rather than individuals, but it's the familiar concept of matters crossing the line. And then 100, accordingly, where a court is considering the existence of the communication crossing the line between one undertaking and another so as to give rise to the necessary common understanding, it's necessary to tread with care. And paragraph 101, second half, what is generally required is some form of communication crossing the line between the undertakings. Since legal persons can only act through natural persons, it must follow, unless a case is very unusual, that the communications constituting the common understanding were between natural persons within each undertaking who shared the understanding. That, it seems to us, is what is required. How it is proved and on what evidence is altogether a different matter. Now, we don't take issue with that reasoning so far as it goes, but where in our submission the reasoning goes astray is paragraph 103. In the present instance, the question arises at how knowledge or states of mind of an undertaking as constituted at a particular point in time transmits itself to a differently constituted undertaking at a later point in time. It seems to us that this case is clearly answered by the law that we've already articulated, provided that the undertaking remains the same undertaking over time, and all that has happened is that the shape of the undertaking has expanded or contracted over time. The common understanding that has, according to the test we have described, been found to exist continues and is attributed to the undertakings on each side of the line until it can be shown that one or other of the undertakings has taken steps to, and in fact has ended, that common understanding. Now, in our submission, that is simply wrong as a matter of law, because a common understanding is a matter that must arise and must persist in the mind of a human actor. And if the human actor leaves, there can be no ongoing common understanding. And we say that this concept of an undertaking that the tribunal is relying upon may well be the unit of account for the purposes of questions of liability, but it provides no answer to the factual question as to whether there is and continues to be a meeting of minds. That, we say, can only occur by way of human agency. Now, I indicated to my Lord Justice Green that the tribunal had cited a case which was to some extent on a par with the points that your Lordship was putting to me. It's at paragraph 104, and this is a case that the tribunal considers to be supportive of its theory, and it's concerned with whether a parent company is liable for the infringing conduct of the subsidiary. And what it's done is cite from paragraph 71 onwards of the judgment. If we look, please, within the paragraph 73, the quoted paragraph 47, we can see it's not disputed that a member of the applicant's management board participated in and even presided over the meeting of PWG until 1988. According to the decision, the main discussion with an anti-competitive object took place in the PWG, and that finding is not disputed by the applicant. And then 49, the applicant's responsibility is not affected by the fact that the attendance of the member of its management board at meetings of the bodies of the PG Paper Board ceased in 1988. It was for the applicant as a parent company to adopt in regard to its subsidiaries any measure necessary to prevent the continuation of an infringement of which it was aware. I do emphasise that because it's important. Furthermore, the applicant has not disputed that it did not even attempt to prevent the continuation of the infringement. This is, in our submission, a straightforward case where the parent company was aware of the infringement and didn't take steps to terminate it. This is not a case such as the present, where there is a mental element, a necessary mental element of the infringement, which subsisted solely in the minds of a particular individual, and that individual left the company.
Was this a case about the duration of a cartel or fines or penalties? Because penalties has the word, I mean, to impose a penalty, it has to be intentional or negligent. So you do introduce subjectivity.
So paragraph 71 within the quote, as regards the duration of the period of the infringement to be attributed to the appellant. So yes, it's about the duration of the cartel infringements in relation to the parent company.
But was that for the purpose of setting the penalty?
I would have to check, my lord, I don't know.
Yeah.
It may well be that it's defining the length of the infringement and then
either
the consequential penalty, yes.
And of course, I haven't got it in front of me, but the condition for imposing a penalty is either intention or negligence, isn't it?
My lord, yes. But in my submission, distinguishing this as concerned with penalties really doesn't assist with the primary question, which is that the tribunal is using this as saying that if you've got the continuation of an undertaking, then the common understanding continues. And in my submission, that simply cannot be right. One has to have that human agency. So we say in our submission, the tribunal's conclusion that any common understanding persisted beyond the 29th of May 2015 cannot be upheld. The CMA's responsive skeleton doesn't take issue, or it doesn't seek to defend the tribunal's reasoning on this. It doesn't say actually the tribunal's right with its theory about undertakings. They say, well, we don't have to show a guilty mind. We can try and infer it from the existence of an objective assessment of the parties' dealings. We make 2 points in response to that. First is, that's a different question. That's talking about how do you prove the common understanding. It's not talking about whether or not one actually existed. And secondly, there's been a finding of fact in any event against the CMA that in terms of the actual factual awareness of the parties in question, the subsequent acquirers were not aware. That's the finding of fact.
I'm taking an extreme example. Mr. Baton was in the hypothetically unlawful cartel from A to Z, from start to end. And in the middle period, he got knocked down and had amnesia for a year. He's the only person who ran the cartel, but nonetheless there was a cartel. But your analysis, no infringement for those 12 months, even though it was implemented.
My lord, one has to... The question of what is implemented is really important in the context of the facts of this case.
They continue to stay out of the market, they continue to receive the imbecilically wonderful deal.
That is point one on the CMA's list of reasons why they say the matters continued in any event post-2015. They say, well, you continue to implement it. To which the answer is, what was implemented were the terms of the written agreement that the CMA accepts do not suffice to show an infringement. So I think I have to concede on your lordship's slightly improbable.
Yeah, I agree, it's improbable.
If, as in this case, one has an infringement that requires this subjective mental element in order to exist, which paragraph 7.7 of the decision appears to concede, then yes, if that element is not present because Mr. Baton came down with amnesia, then the infringement doesn't go on. Thomas rightly reminds me that there's, of course, a body of law on whether one can find a single and continuous infringement when there are temporary gaps in the
operation.
The facts, essentially. Well, one assesses it on the facts of the particular case, and so one would inquire in those circumstances, is it a single continuous infringement, or would one analyse it as an infringement for this period, an infringement for that period, and a hiatus in the middle?
Yeah.
Your Lordship has our submissions on that. And Lord Teness, I can assist further, those are my submissions.
Thank you very much. Anything else? No. Thank you, Mr. Joe.
May it please your lordships, might I have a moment just to take my stowaway? To use it, which to leave my notes. My lords, I will be addressing you on three main matters. First of these was going to be the first ground of the CMA's appeal, which is their jurisdictional ground, the issue 2. But as I understand it, that has now been withdrawn and replaced with a new ground of appeal. And so I will largely be dealing with that new ground of appeal. Secondly, the court has invited submissions by the parties on the topic of, if I may summarize, what went procedurally right or wrong below. And I've got the short straw, and I will be addressing you on that topic. And then finally, I want to make some brief points from Allergan's perspective on the issue that Ms. Ford has just addressed you on issue 6, the question of the duration of the agreement after May 2015. Before I turn to the new ground of appeal, I should just say something briefly about the old, because it is illuminating in relation to the first two issues. Ground 1, as you'll find it's in the, don't need to turn it up, it's in the core bundle at page 56, paragraphs 83 to 87 of the CMA's skeleton argument. And you'll see that it's a technical argument to the effect that after H2, the tribunal was functus officio. It doesn't depend at all on the substantive correctness of either H3 or indeed H2. It's simply that because the certain paragraphs of the H2 judgment were in unqualified terms, therefore, and in a sense because the tribunal didn't use the word provisional expressly in H2, therefore its authority had expired and it had no jurisdiction to reach a different conclusion in H3. Now, that ground of appeal is, I think, no longer pursued, and it was wrong for essentially two reasons. First of all, the CAT plainly has, in theory at least, jurisdiction to reach provisional conclusions or provisional findings on which it can then invite further submissions. And if it does so, it's entitled, perfectly entitled, to change its mind in a subsequent final judgment. And secondly, the CAT's decisions in H2 are provisional in relation to the disposition of the appeals. And despite the trenchant language sometimes used, or very clear language used to express the provisional views of the tribunal, they are expressly subject to consideration of whether the CMA's case was or wasn't fully put to the witnesses. Now, on the first point, there is a well-established principle that a judgment and order in the High Court, at least, can always be amended at least until the point at which the order is perfected. And if authority is needed for that, and by which one means in the High Court sealed, if one needs authority for that, it's in the authorities bundle at tab 57, paragraph 1 of the Supreme Court's recent judgment in AIC and Federal Airports Authority. So that is the general position that a court is always entitled to change its mind right up until the point in time at which the order is sealed. This is, of course, a tribunal, and it's right to say that in the CAT, appeals are made from decisions and not from orders. That is a result of Section 49 of the Competition Act and Rule 107 of the CAT rules. But the CAT has got wide powers, both to deal with cases justly, to invite submissions on certain aspects of the proceedings, and to regulate its own procedure, and indeed to vary and revoke previous orders. Those are rules 4, 19, and 115. So we say that the CAT has, in principle, the same power as the High Court to hand down a judgment that reaches a decision on a provisional basis, and then to invite further submissions before it reaches a final decision or a final disposition. And secondly, we also say that when one reads H2 as a whole, it clearly was only reaching a provisional decision. And I think that Mr. Turner was effectively accepted. I think he accepted on in the transcript on day 2, pages 3 to 4, that it's common ground that the only findings that are truly determinative in H2 are those that invite further submissions and the consequential directions in relation to those submissions. Now, just pausing there, the fact that the tribunal had the power, the jurisdiction to hand down H2 does not mean that it was a good idea for it to have handed down that judgment in the form that it did. And that is something that I will need to address you on when I come back to the question of what went procedurally right or wrong here. I simply make the point for present purposes that it did have the jurisdiction to do so. And it is also important, I think, to observe that the ambit of the additional submissions that the tribunal invited the parties to provide was not quite as narrow as I think Mr. Turner might have suggested. He took you to those parts of the H2 judgment that explain the need. The tribunal said, we need further submissions, and it focused in articulating the reasons for those further submissions on the allegations of intentional infringement, of sham and dishonesty. Those certainly formed the focus of the tribunal's articulated reasons for needing further submissions. But the ultimate invitation for further submissions was not confined to those topics. It was broader than that. It was expressed as a potential failure on the part of the CMA to put its case to the witnesses. And one can see that if one goes back to H2 in the core bundle at 419, page 419, paragraph 25, we see, we are concerned, says the tribunal, that the CMA's case was not fully put to Mr. Sully or Mr. Bateman. We express no concluded view on the point, not least because the parties have not had the opportunity to address us on this point, nor on the implications of it if it is well founded. They say that they propose to decide the issues arising out of the appeals on the basis of the evidence before us. That's self-evidently a question of reviewing the factual material, and then it talks about carrying out that exercise in section B and then conclusions in C. And then it says in section D, we return to the concern just articulated, the question of whether, in light of our consideration of the evidence and the findings we've made, the CMA put its case, and if they did not, what the implications of this are. And when it comes back to the point of paragraph 157, which is on page 489, 1573, it says, assuming without deciding that the CMA's case was not fully put, we want to hear from all interested parties as to the implications of this. So they are making clear that this is all subject to the unresolved issue, which is put quite generally, whether the CMA's case was fully put to the respondents' witnesses.
I mean, that paragraph's a bit confused, isn't it? Because it then goes on to say the CMA has made a decision which we consider on the merits to have been correct.
It is confused, but it is nevertheless clearly inviting.
That's your point, that this wasn't a good idea.
Yes, and I will indeed come on to that, if I may.
Can I just test the proposition that in fact it was broader than sham or intention? Clearly sham and intention were the two things which it refers to, and really one reads from 149 onwards under the heading findings of dishonesty, and those were the two things which weren't properly examined, which the CAT thought were directly relevant to dishonesty. I mean, sham and intention are part of their case on dishonesty. I mean, read from 149 onwards, are they really saying we're going to open Pandora's box?
Well, it is expressed, the invitation is simply, and the concern as initially articulated, you see in those paragraphs 25 and 26, is put very generally. It is simply, was the CMA's case put to Mr. Sully and Mr. Baden? I accept that the articulation of the reasons focuses on those specific elements.
I mean, on one analysis, they were concerned about sham, intention, dishonesty, but when they come to H3, as we saw from the submissions that were put to us on some day last week,
Yes.
they immediately open the matter up to going back to what the CMA's case was or ought to have been,
Yes.
which on any analysis goes beyond sham, intention and dishonesty. That is then a complete rehearsal of what CMA's case was or ought to have been. And was that appropriate in your submission?
Well, my lord, it was within what was reserved for further submission, because in my submission, because one looks at 25 and 26, and one looks at 1573. They are simply saying our concern is, and we invite submissions on, whether the CMA's case was fully put to the witnesses.
But
And if that is the concern, the starting point of the analysis has to be what was the CMA's case. So I'm inclined to defend the tribunal in that respect, in the sense that it wasn't exceeding really what it had set out in the first judgment. And if I could, I think we sent over this morning, I think, a letter from the CMA that is, if I may, for those who want paper copy, which was provided to the tribunal prior to second hearing. Dated the 5th of October 2023.
have we got this electronically?
Yeah, it has been sent to the court electronically. We would like a copy. Oh, of course.
When was it sent?
Was it sent to the...
Where's this in the bundle? What is it?
my lord, it's not in the bundles.
What is it?
It is a letter from the CMA
Right.
to the Competition Appeal Tribunal, dated the 5th of October 2023. And I can simply read what it said, if I may. It's prior to the hearing, the subsequent to H2 being handed down. And over the page it says, "We note that the tribunal's order requires the parties to produce and file any skeleton arguments by 4 p.m. on the 24th of October. In preparing its skeleton arguments, the CMA refers to paragraph 25 of Hydrocortisone 2, which sets out the tribunal's concerns that the CMA's case was not fully put to Mr. Sully or Mr. Bacon, and to paragraph 1573, which sets out the tribunal's desire to hear from all interested parties as to the implications of this. If it would assist the tribunal to address any other matters, we should be grateful for this direction." So I respectfully say that is what the judgment invites submissions on. That's how the CMA itself understood it at the time, not as confined purely to dishonesty and so on.
It doesn't really condescend to which aspect of the case wasn't put.
No, but nor in my submission really did the tribunal limit itself in that way. It didn't ask for submissions on.
Well, what is really surprising, if you were right in saying that somehow this was all, as it were, open to being revisited,
Yes.
is how on earth the tribunal could have thought that it was appropriate to make the findings that it did make, culminating in paragraph 156. Because surely if it had thought that the case hadn't been put properly in a general sense, as opposed to in the limited sense to do with sham and intention and dishonesty, it would have said, we cannot reach a conclusion of any sort in relation to whether or not there was an infringement because the CMA hasn't put its case properly.
Well, my lord, I agree to this extent that the tribunal should not have handed down the judgment H2 in the form that it did, and I will be addressing you on that shortly. But I don't think that one can read from that its only concern was necessarily limited to those matters. That's not what it invited further submissions on, and not what it went on to consider. well, in H3. and of course it does, the tribunal does make clear in 1573, 157 and following, that its judgment is indeed a provisional one.
I mean, what's obvious, I think we can all agree this, I don't think it's even in contention with the CMA, is that had the tribunal wanted to hear half the case and hand down lots of ideas and findings and provisional decisions and law and anything it wanted, and then said, provisional, now I want to hear the argument again, that is a process which is open to a tribunal if it wants.
Yes.
Crazy, but open. Yes. And that's fine. But that's not what this tribunal did. This tribunal reached findings on the substantive appeal, reached findings on dishonesty and an agreement, which was not what the CMA had put, and then said, on the basis that those findings are provisional, we want further argument. Now, that is, and this is why I want submissions from you,
Yes.
as it seems to me anyway, at the moment, that is a more than just doing what I put before, writing a big judgment with lots of law and facts and writing a big stamp on it, provisional, ignore all this, you know,
Yes.
but I want to hear some more submissions.
No.
It's doing more than that. And the question is that an appropriate cause for the tribunal to adopt or not? And if not, why?
My lord, I will address you on that. My intention.
What's the answer?
No, it is not.
It's not appropriate.
It's not appropriate.
No, it's not appropriate.
No. And have you appealed that?
No, we don't need to appeal, my lord, because the ultimate disposition is in our favour. But we do say that those findings are. I mean, we just heard Miss Ford appealing the fact that the tribunal has overstepped the mark. So yes, in a sense, we do appeal. We do appeal those points, or cross appeal, if you like, on those points.
Well, you apply
by way of respondent's notice. But,
yeah. Respondent's notice is different. You apply upon the
Yes,
basis
that's
that,
right.
that Mr. Turner wins his
Yes,
appeal.
yes, indeed.
Something's resurrected, and in those circumstances you appeal. But
Yes, indeed. So on that, so strictly. So the answer to my lord's question, my lord the Master of the Rolls question is, yes, we do appeal in the sense of respondent's notices, but we don't.
What is the essential legal error in doing what it did?
Well, let me. I was going to go on to the new ground of appeal, but let me take that straight away.
Well, only because I just want to have it
Yes.
in mind.
Yes, no, of course. We say that the key misstep that the tribunal took was handing down the H2 judgment at the stage it did and in the form that it did. And what the tribunal should have done, if it had these concerns that the case had not been fully put to the witnesses, is to simply not to have handed down anything that resembled a judgment, but simply to have invited further submissions on the point. Now, it's also possible to identify other missteps, both before handing down H2 and after handing down H2, and I'll come to that.
I think my lord's question is, how do you legally analyse this?
Well,
it's either functus, and if it's not functus, I suppose the only other heading is its rationality. Is it irrational and therefore unlawful to do what it did? I mean, it may or may not be functus.
Well, we say it's not functus.
No, right. Let's assume you're right, but you say it's wrong.
Yes.
Why is it legally wrong?
Well,
Isn't it because it's irrational?
It's legally wrong for two reasons. First of all, it's entirely appropriate in some circumstances for a court to hand down a provisional judgment that deals with, say, deals with all the facts, but it leaves outstanding a point of law. It says, well, I want submissions on the point of law. Or to say, I find facts 1 through to 10 as follows, but on facts 11 and 12 I want further submissions.
What nearly always happens in my experience is that the court doesn't hand down judgment at all.
Yes.
And simply says, having reflected something like,
yes.
and we've all had this as
yes.
judges, you suddenly think, when you go away and try and write the judgment, you think, hang on a moment, there's this point that haven't really been properly addressed on yet.
Yes.
So you just get the parties to come back in for a day or whatever,
yes.
and you have further submissions, and that happens quite a lot.
Yes.
And then you issue one judgment.
Indeed. Indeed.
And there were the good old days of judges that none of you will remember, like McGarry and Millett, who loved doing their own research. And you'd do a case in front of them, and you'd think you'd quoted every case that could possibly be thought of in the reign of the world. And they would go away and they'd come back and say, well, there's these 6 cases I haven't been addressed on. Can we have another 2 days? And there we are.
Indeed.
All the freshers were incurred. But you didn't get the judgment before they had rehearsed their research. And that's what's unusual here. Now, you tantalised me, Mr. Joel.
Yes.
You said it was legally wrong for 2 reasons.
Yes.
And then you said what was right, but I want to hear what was legally wrong.
Right.
Those
well, there are
2
two.
reasons.
These are them. In my respectful submission. So the first is that what is odd about this particular form of provisional judgment is that it's not a judgment where, as I said, you've got a discrete point of law or fact that is outstanding. Instead, what you've got is essentially a judgment that analyses principally the documents, and perhaps, as my Lord the Chancellor observed, some of the evidence in the first, but leaves over the effect of the principal witnesses' evidence and whether they were challenged or not on what it perceives as being core points of fact.
We can't really be said just to do that. I mean, I follow that point, if that were right. But they found that Mr. Bateman was dishonest.
Yes, well, this is... I'm going to come. That's the second point. That's the second. That's the second. But even if one had shorn away...
You can't get away with that, because you said it's legally wrong for 2 reasons. I've written down what you wrote. The first is, what is odd is that it's not a discrete point of law outstanding. It's essentially a judgment that analyses some of the evidence and the documents, but leaves over the effect of the evidence and the challenge.
Yes.
Okay, is that wrong in itself to leave over the effect of the evidence and the challenge, or what?
Yes, it is, because
it is wrong.
An appropriate. It's not appropriate to bifurcate a judgment between the assessment of different parts of the evidence, the documentary, the assessment in my submission of the evidence, the documentary and witness evidence should be a single unitary exercise. Now, again, it's true that within a judgment, one often sees distinct analysis of the documentary evidence, the inherent probabilities, the witness evidence.
But you say the evaluation of the evidence.
Yes.
Particularly in a case where what's alleged is a nod and a wink understanding.
Yes.
Is a single unitary exercise.
Correct.
And what you can't do is make findings about bits of it and then say you want more submissions on other bits.
Correct. Exactly, my lord. We say that the separate analysis of the various elements has to be provided on a single occasion and as part of a single judgment, synthesizing those various elements and reaching a final global determination.
What's the legal tag? I mean, you said not appropriate. Do you mean irrational? Why is it unlawful to do that? Maybe bonkers, inconvenient, waste of money. Why is it unlawful?
I say it's been suggested to me that it's procedurally unfair. I think that is
a recognised heading.
That is part of it, but it is also, I would say, an irrational exercise in judgment writing to reach clear conclusions are only on part of the evidence.
Now, where in your submissions does it say that the process that the tribunal followed was procedurally unfair and an irrational exercise of judgment writing? I mean, I'm not saying you don't. I'm just saying where is it?
We do say. I was going to make some submissions.
Is it in the respondent's notice?
I think there are. One can certainly. Well, it is. I think not put in that way in the respondent's
To be
notice,
implied.
because I've been invited to make submissions on.
No, okay. It's
on
fine
the-
if it's new. That's fine.
Yes.
I just want to know.
Yeah.
I mean,
But-
so
So it's-
you basically say that you can't bifurcate the fact-finding exercise,
Yes.
which I get, but
that point.
I have a problem with that because surely this judgment, in one sense, did have the big red provisional stamp on it, because when they came to revisit it, they said, and as a result of revisiting it, everything we said before is thrown away.
Yes. Well, can I come on to that in a moment, because I want to give you my second point before I do. The second point is this: that what makes the situation particularly unorthodox is not just the bifurcation, but the content and the tenor of the findings that are made, and that is the point, that there is a finding of dishonesty against a witness made in circumstances when the decision maker and the CMA and the cross-examiner expressly disclaimed any suggestion of dishonesty, and that could never, in my respectful submission, be an appropriate finding in a judgment. And there are also the findings purporting.
Can you just help us, because we asked the question I
Yes.
think last week? What was meant by dishonesty? Was it meant in the Ivy and Ghent two-part subjective-objective test, which they didn't apply, manifestly?
No.
Or did they simply mean, we don't believe him, he's a liar, which they
I
also
think it's in the second sense, but whether it's, but I think it doesn't matter. I think when a cross-examiner says we do not make an
No,
allegation,
we understand that point.
and the judge nevertheless,
Yeah.
but that is, in my view, respectful submission, procedurally unfair.
It was a
quintessential
label,
example.
a highly pejorative label, which wasn't, on
Yes.
CMA's case, necessary.
Well, it's worse than that in a sense, because it goes against the principle that you saw in the Griffiths and TUI judgment in the Supreme Court, which says that it's unfair because the witness must be given a chance to explain, and it's I mean, and that judgment goes quite far, and it says, well, any sort of important finding, if you're challenging the witness, has to be put to the witness, but it's absolutely paradigmatic that an allegation of dishonesty must be put to
But
the
yes, I mean, there was a subsequent case called Ulla, where that point on dishonesty precisely came
Yes,
up.
indeed. And if the cross-examiner says, as Mr. Mitru did, quite rightly, says, I am not making a case of dishonesty, no judgment should then say this witness is dishonest. That is what those are the 2 points that, in our submission, made it that, and also the, as we said, the unqualified nature of the findings that are made, also in relation to the sort of theoretical disposition of the deal, are also.
Tell me about this then.
Yes.
In the light of what you've just submitted. Let's just assume, for the sake of argument, that we're against you on H3.
Yes.
So we don't think H3, anything of H3 at all. What do we do about H2? And what do we do as a Court of Appeal? Are you suggesting that we have to say, well, it's all got to go, so there has to be a retrial, or what?
I think that if that were the conclusion, then yes, and I'll come on to that, because I think can I deal with that point when I come to address?
No, of course. I just want
the new ground of
I
appeal.
just want you
Yes,
to
in a nutshell.
If
In a nutshell,
ultimately that is what you're saying,
Yes.
then, well, fine.
what do you say? Sorry.
We do say that we say that, well, if you are not with us, that that H3 is rightly decided, which we do, and we do say H3 is rightly decided, essentially for the reasons that Ms. Ford has articulated, and indeed Mr. O'Donoghue and Mr. Brearley. Then we do say that there isn't another way through to bring back H2 from the dead, as it were, and it would be necessary to have a rehearing.
A rehearing is necessary.
Yes.
And the decision is thereby resurrected, pending a new appeal.
I think that must be right. But if I may come back then to this question of this tangled question of what went wrong. So we say, in short, what's happened is that the judge took the judgment out of the oven, as it were, too early, and without adding the yeast.
Sorry, sir.
It took their judgment out of the oven too early, and hadn't added the yeast to it, and so then to put it back in the oven with the yeast is not going to produce very good bread. So that's essentially, if I may use an analogy.
They put quite a lot of chili powder into the bread.
Yes.
Flagrant violation.
Yes.
Imbecility.
Rather than sourdough.
Yes. We say that the appropriate approach was simply the tribunal should have articulated its concerns about that the CMA had not put its case to the witnesses and invited further submissions. I should say the tribunal defends its two-stage approach at paragraphs 136 to 137 of the Hydro judgment.
I think it actually says that it was forced upon it.
Yes, that's right.
I'm not sure if it was your fault, Mr. Jowett. Were you there?
I was at the first hearing of H2, but not of H3.
Might have been your fault.
Absolutely.
I hope not. We certainly never invited the tribunal to provide the judgment
136
on a partial basis.
136 and 137.
136 and 137. It's at 388 of the bylaw. And
Sorry.
it should,
H2 or H3?
H3,
Oh, sorry.
page 88 internal.
Yeah.
and I should.
Well, they're really saying it's not our fault.
Not our fault.
Non mea culpa.
Yes. In our submission, that is not really a complete answer because the tribunal wasn't compelled to hand down its its H2 judgment. As I said, it could have simply called for further submissions. So I should just briefly address you on whether there were other procedural errors in addition to what we say the premature handing down of H2 in the form that it took. It's possible to make the point, as my Lord the Chancellor explored in the course of argument, that if it had these concerns at the stage of the cross-examination, the tribunal should have made it clear there and then if it thought that certain matters were not being put.
Yeah.
On this, whilst we certainly can see that was an option that might have been open to the tribunal, we're inclined to defend it because there is a line of established cases, Jones and the National Coal Board and so on, which do say that they go much further back than Jones and the National Coal Board.
Well, the oddity, though,
Yeah.
and the context in which I put that last week, and I'm acutely conscious of the point that which I think the President makes himself about not descending to the arena.
Arena, indeed.
But he had, in a sense, because there's 20 pages of cross-examination of Mr. Baton by the President and other members of the CAT in any event. So that if one does have the slight concern that if after all that, if I can put it that way, they still thought there were things that hadn't been put that should have been put, I think that was a sort of natural moment to say something. But there we are, they didn't, and that's...
They didn't. I think, in my submission, was within their discretion not to do so. There are many cases where the courts find a particular point has not been put, and therefore they find against the party on that basis. And it's no criticism of the judge. The judge didn't step in at at the moment of the cross-examination and say, you haven't put this point, I notice you haven't put this point, are you going to? Which is not to say that the judge can't do that necessarily in certain circumstances, but I don't think it can be said that that is in itself a criticism. And then there's the question of, well, what about after H2 is handed down, albeit in this closed format? Was it wrong for them to then continue to allow it to make it public and to put the health warning on, as they did? And in our submission, at this stage, there really is no good option available to the tribunal. There were only least worst options available. We submitted on behalf of Allergan that the appropriate step, given that it was a provisional judgment, and given that these findings of dishonesty and so on were clearly not appropriate, would have been to have withdrawn at least all of H2, other than the first 24 paragraphs, which are innocuous. And we do continue to submit that that would have been a better course. But of course, there's no really good course, because, no pun intended, the cat was out of the bag once the H2 was handed down.
I think a pun must have been intended.
And so the...
But it was a closed judgment, though, wasn't it? When it was handed, and it was
a
handed
closed
down
judgment.
in one sense, but it wasn't. It was closed.
Indeed.
And remained closed until the cat opened it.
Indeed. And
So it wasn't. So the cat wasn't actually out of the bag.
No,
It was still
no,
inside the bag.
No, it's still inside. That's a fair point. And that's why we submitted that actually the better course, and we continue to submit, would have been to have simply withdrawn all of that, and then you would have had a single, effectively a single H3 judgment.
I mean, you say, I think, all of you say, Cat didn't put a competent case to the witnesses. The witnesses were put in an unfair position for a number of reasons, the 50-50 point and on from there.
Yes.
They weren't ever challenged with this alleged common understanding properly, even though theoretically an alleged common understanding could exist without dishonesty, because there could be other explanations for it. That wasn't put adequately to them. And so what the CAT should have done in H2, having decided to go to 20 pages of cross-examination of their own, but not to 40 pages of cross-examination, was not to make findings of dishonesty, was not to make findings of a common understanding that had not been put, and they ought then to have decided the case on the evidence and against that backdrop, and had they done so, they would have allowed your appeal, because there wasn't a common understanding on the evidence, and the inference couldn't be drawn in the absence of further things being put. That's your case.
Yes, indeed.
And you say, so actually, there was never, and you agree with Mr. Turner, I think, ultimately, that there was no need for CAT for H3. What should have happened is they should have sat in their private room and considered all the evidence and all the documents and reached a different conclusion. And there we are. They shouldn't have found dishonesty. They shouldn't have found a common understanding. Had they not done that, then they wouldn't have made the inferences they made that the CAT was right, the CMA was right, and they would have allowed the appeal. I mean, that's your case.
That's our case, and ultimately, that's what the CAT has done.
But that's a sort of in a manner of speaking. But
yes.
I'm combining the substantive and the procedural.
Procedural, yes.
And if you combine the substantive and the procedural, the Council of Perfection would have been that they finished the hearing, they've done their cross-examination, the CMA sticks by its point, they don't accept that's good enough, for whatever reason, and therefore they should have simply allowed your appeal at stage 1.
Yes.
And they didn't do that, you say, and a plague on them. That must be, either that's the outcome now, or there has to be a retrial because they've messed it up.
Well, yes, I mean, but as I say, I think that in a sense, that is the outcome now. It's simply that they have arrived at that by a very curious process of handing down a provisional judgment and then disclaiming it, and then providing H3, which we say effectively got it right.
But the problem I have
Yes.
with the outcome that is finally reached is
Yes.
I cannot square, in my mind, the actual findings of dishonesty of a witness on the evidence they heard, on all the evidence they heard, the finding of an understanding on all the, and a conversation on all the evidence they heard, the finding that the CMA's decision was right on all the evidence they heard, and then sweeping it all away on the ground that bits and pieces were not put. It seems to me that that doesn't read together in a coherent way at the moment. And something's got to be done to unpick that lack of coherence, either your solution or probably Mr. Turner's, one of Mr. Turner's solutions. But
Well,
I don't think we can all have it both ways.
Yes.
And then they can have it both ways.
My lord, I see that it's an as we said, an unorthodox process by which we've got to the result that we've got. But nevertheless, we say if we're right that the points weren't put, then the H3 is correct.
I mean, if you're right, you're right.
I should point out one thing. The tribunal itself in H3 characterises its previous judgment at paragraph. This is paragraph 16 of H3, 310.
16.
Yes, paragraph 16. And you see the last sentence, or the last clause of paragraph 16. They talk about the basis for they say, fatally undermines the conclusion otherwise open to the tribunal and the basis for the provisional findings in the H2, that there was sufficient material to uphold the decision when considering in substance the documentary evidence alone. So that's how
that's just not what they did.
they may have gone a bit further, but they certainly didn't. They didn't really examine the effect of the two main witnesses. Mr.
I mean, the real problem is I've had the misfortune to actually look at H2 in quite a lot of detail.
Yeah.
And the problem with H2 is that it doesn't do one thing or the other. It raises some documents and some of the evidence.
Yes. Well, I see.
And then gets to a magic conclusion at the end with a magic wand.
Yes. But it has been disclaimed by the tribunal. Hence the rubber stamp on every page.
I mean, your submission is clear.
Yes.
And you say, even if parts of this process could be defended, you say there were two essential problems with what happened.
Yes.
And your preferred submission, I imagine, is that they should simply have dealt with it on the evidence, and had they done so, the case wasn't properly put, and therefore they lost.
Yes. Or as I said, they could have invited further submissions and then provided them.
Yeah, and if it's all too bad,
Yes.
then worst case retrial.
Yes.
What you can't do is miraculously
No.
allow the phoenix to rise from
From
the
the ashes. And may I just on that just briefly address this new ground of appeal which seeks to do that.
Yes.
And what it seeks to do in a nutshell is effectively to prune off, as it were, the findings of dishonesty from the judgment and the findings about the importance of sham and intention and so on, and to say that that they should have simply decided the matters on the evidence and no further substantive hearing was ever required. And so if you prune away those unfortunate bits of H2, then you reinstate the rest of it as though it were a final judgment. And I can certainly see there's a very neat solution, but I'm afraid to say, and I appreciate this may not be an entirely popular submission, but we just say it just doesn't work here. And the first reason is this, that the central debate between the parties in relation to the CMA's decision was always whether there was a commitment given by AMCO to Orden not to enter the market that was additional to and different from the commitment embodied in clause 2.2 of the second written agreement. Now, and so whether that additional AMCO commitment was given or not, and if it was given, how it was given, this was the central issue on the appeal. And so when one comes to the finding in paragraph 1448, which you've been shown already, but I just would make a few further observations about it. It's in the core bundle at 483.
This is 1448 in
Yes.
H2.
Yes, page 483, 1448. And first of all, it's a finding of a conversation at which an agreement was reached. So it's not some sort of implicit agreement. It seems to be an express agreement. Secondly, it contains the term not only that AMCO would stay out of the market, but also that AMCO would take Orden's products and sell it at around the prevailing market price. So it's got an additional term.
Price fixing.
Price fixing, effectively. And also, if one reads it together with 8.1, it says there was ample opportunity for Mr. Baton to strike this deal with Mr. Patel. There were, as we've described, a number of conversations between these persons which were not documented and which should not have taken place. So it's really implied that it was a hidden agreement, and if not hidden, then at least undocumented. And we say that so on no conceivable way can this be confused with the CMA's case. The CMA's case really now centres on the threat exchange, or on an unspoken premise. This is simply something a completely different animal, and there's no getting away from that. And it doesn't consider, the judgment simply doesn't consider whether the matter can be considered.
So why does that matter to the conclusion that the CMA's case in the decision was sustained? I mean, it is an overlay, right?
Well, in our submission, it's more than an overlay. It's a completely different case, and this is on the central.
It goes further than you say it goes further than what the CMA were alleging. But the CMA were alleging, were they not, that there had been a conversation between Mr. Patel and Mr. Baton, at which an agreement was reached, whether it was a nod and a wink or more than that. Presumably, if it was a conversation, it would have been more than that. That AMCO would stay out of the market in return for taking Orden's product, or putting it the other way around. Orden would supply the product on the basis that they would stay out of the market. The bit that wasn't the CMA's case, as I understand it, is that it was to be sold at the prevailing market price. Although that would be, might be said to have been a fairly obvious inference from everything else.
Well, in my submission, this comes back to Griffiths and Toohey. This was simply never put to Mr. Baton. It was never said to him, you have an agreement, undocumented agreement, in which you agreed these two things.
Was there no cross-examination about? I think they came into the market a bit higher, didn't they? They were £1 or so above most of the time, above Orden's pricing.
Yeah.
Was there any cross-examination about that?
Didn't they predict that Orden wouldn't respond if they were at or about or slightly above, provided they only got their portion of the market? Because that would still leave them with unfettered access. So they didn't want to shake the price. They didn't even want to go a pound below. I mean, that was the evidence. But there's a more fundamental point. This is a finding of fact. If the CAT had said, we agree with our findings of fact, we now come to the conclusion, they just uphold the decision. The reasoning which leads them to uphold the decision might be slightly different, but that might just be the end result. We uphold the decision. Now they've got the power to make their own decision, but here they would have just said decision upheld. Slightly different reasoning. Maybe we've gone an inch or so beyond, or a foot or half a mile beyond, but we uphold the decision. Isn't that within the rules?
No, because that's just not what they've done here. I mean, they found a different. The central issue was how on this appeal was this commitment given and in what form, and they have found it in a completely different form to that which the CMA cross-examined on, and no one cross-examined on this form.
Procedural point. I mean, if you're writing the procedural point, you get home on that.
Yes,
but in terms of this just being beyond the decision, I mean, separate that the procedural point. If it's procedurally unfair, so be it.
If the CMA had said in the course of the hearing, well, actually, you know what, you didn't document your points between you and Mr. Patel, and at some occasion, you reached an agreement with him in these terms, didn't you? If that had been put, I say fair enough. Yes, that goes a little bit beyond the specifics in the decision making, but that is not what happened. They didn't put it on that basis. They put it on the basis of the bluff, the threat, and they continue to put it on the basis of that. The CAT doesn't directly address in H2 the threat point. It does in H3, and it says that's not enough. In its mind. So what one can't do here is just, as it were, swap out this finding in 8 and say, well, let's put in the threat instead, because that's a completely different hypothesis.
Don't we need to look at how it was put by the CMA in their closing submissions?
But not
how was it put by the CMA in its closing submissions? I mean, their case was that there had been an agreement. I mean, whether not an agreement in a contractual sense, but at least sufficient to cross the line, using the CAT's phrase. That was the CMA case.
They do, but the CMA's case was, as I recall, was that they would not. They say, Mr. Mitriou, I think, said, I'm not saying there was a side agreement. He specifically said, I am not saying that there was a side agreement. And this is a side agreement with bells and whistles on.
Well, no, I'm not sure about that. I mean, I've always thought the reason why she said there wasn't a side agreement was because what she was saying was the written agreement is not the totality of the agreement. So it's just a bit of it, if you like. The agreement, the overall agreement, included this aspect that was, for example, what she did put to Mr. Bacon about the 15th of June email and what he and Mr. Patel had discussed. So it wasn't that she wasn't saying, well, it's part of the agreement. She just wasn't prepared to take the side agreement so collateral.
She says it's the 10 milligram agreement.
Yeah.
This defined bundle, the 10 milligram agreement, which is what was agreed orally on the 27th and 24th of, I can't remember the date, but 2011, 2012, between Mr. Patel and Mr. McEwen. And that never changed, and when they came to reduce it in writing, they didn't record what had been agreed faithfully, and it never changed right to the very end. They continued to make the money.
Evidenced by what was discussed between Mr. Patel and Mr. Bacon.
Well, can I show you the way it was put? It's in the supplemental volume 20, tab 22, page 1928.
This is in cross-examination.
This is in closing.
Closing oral submission.
Closing oral submission.
this is, sorry, tab 22.
Tab 22, page 1928.
Well, I don't know what, tab 22.
Oh, is it 20? Forgive me.
Have you got a good,
It's page 1928.
It's your case, it won't be. What's the
Oh,
internal?
forgive me, it's page 13 of the entire.
13.
13.
13?
13. So sorry.
1915.
And you'll see at the
Do we have the written closings? I was just trying to hunt down the CMA's written closings. They're presumably somewhere.
find out. But we see what was the way the case was put was essentially as a premise or a recital to the agreement, as though it were a recital to the agreement.
Tab 17.
See, and at the top of the page we see that is not a rider or an additional term that is absent.
Well, you've got to read the whole thing.
Well,
Actually.
one does have to
It's 2.5 pages. It's
Indeed.
just worth reading.
Yes.
It's pretty clear.
One does need to go over the page though, because well, let me focus on. I'm very happy for you to read the whole thing from page 12.
And this is closings in H2, by the way, is it?
Yes.
No, yes, this is
Because it's Mr. Mitchell, isn't it?
Trial.
Who wasn't there at H3.
Yes.
So we've shown this before, I think, by Mr.
Yes, I think over the page, I think it's important. At the bottom of page 13, we do not need to show that it is dishonest. We do not need to show that it is a hidden term. We do not need to show that it is a side agreement or a rider. Well, but that may or may not be right. But what is unmistakable is that the CAT does find a side agreement.
Well, what's interesting is that the whole, the CAT never puts the facts chronologically in order with the documents and the evidence, and says it all started in the beginning with the 20 milligram arrangements, which are themselves subject to a lengthy decision in H1. And then there was the arrangements between Waymade and Auden. And then the personnel changed. And then there was the first written agreement. And the first written agreement was made for different things. And then there was the arrangements with Isika. And then there was the second written agreement. And then there were conversations with Isika. And then there were more conversations with Isika. And then there was the cancellation. And if you put all that together in one place, you get a picture. Right? But that's never done.
No.
It's all in different places. And I say, unusually for me, Mr. Jowl, I've been reading the papers. And it's all in different places.
Yeah.
And I mean, I've never been told that competition law doesn't involve looking at a chronology of what happened. Maybe it doesn't. But I find that helpful.
Well,
because then you can identify the stages at which it is said things were supposed to happen.
I very much see that, and that
And
comes on to-
you've never given us a chronology.
And then you see a point about where you draw an inference. It's much easier to see
Yes.
why it's appropriate or not appropriate to draw a particular inference when you look at things in the round chronologically.
My lords, I couldn't agree more, and I don't want to get into what was called the ambulatory draft history, because that is another saga.
What happened?
The ambulatory draft.
It's ambulated.
There was a
Where did they fit in? Where were they required?
the ambulatory
Oh,
draft.
the ambulatory draft of the SWA, yeah.
Yeah.
No, of the.
There was an attempt by the tribunal to grapple with this issue of the need for some form of chronology. I think it started with a proposal, I think, and I hope I won't get this wrong, but I think it started with a proposal that the tribunal would produce an ambulatory draft judgment. This,
really?
this, as you expect led to some objections from the parties that were not appropriate to them. And that the tribunal then clarified that it was not a judgment that it was seeking to draft. It was simply a document. And the document would try to, I think, essentially contain the parties' different versions of the facts, or insofar as it was possible to agree them, agreed facts. And ultimately, the parties went back and forth in numerous iterations of this, and the document grew and grew and grew. But I don't think it was eventually.
It happened.
Yes, this happened. I don't think it eventually finds its way into the.
There was a well-known judge in the commercial court who used to get the parties to agree the facts, which then appeared as the first part of the judgment, and then they had to put in their argument, which appeared as the second part of the third part of the judgment, and the decision was always very short at the end.
Yes, 2 paragraphs.
So this was tried here, was it?
This was attempted. It didn't succeed. I think it's fair to say. At least it was not used in the judgment.
And was there ever an agreed chronology?
Other than the ambulatory draft, I don't.
Well, if I
think so, but
just insist on that, it wasn't necessarily agreed, but it was. I think it was 98% agreed. It is attached to our closing submissions, and that is at the unagreed bundle, tab 14, page 698, and that's just to pick up the point, my lord. We did set out in absolute granular detail the chronology starting from October before that, but from 2012, 13, 14, 15.
So which tab are we in?
Well, it's tab 14, 698. This is attached to our closing submission.
Just to enter the point that this was not agreed.
Well,
I think it's agreed that it's not agreed.
And
it was largely agreed because it's
394 paragraphs.
95, yes.
Sorry, where am I?
So this is tab 14, 698. We went through all the documents, all the contemporaneous documents relating to the first period, about how AMCO sought expedition of development, how it then decided to launch its own product, the board meetings which set out the decision to launch, the management decisions which terminated the supply with Auden, the reasons why they entered a second agreement because of the orphan designation. We set it out in great detail by reference, as you can see, to all the content in this document.
I can see you bear the scars of this document.
I bear huge scars. Yeah, I drafted it. And I'm sorry, but that is why I think I said it right at the beginning. When one gets to the first period, we only see 2 paragraphs really at the end of H2 which deal with this. Which deal with the first.
Where did I'm sorry, Mr. Jowell, if you don't mind, I just asked to talk really this. You know the tribunal has period 47 and period 48 and week 79 and so on, which is, but nowhere do they seem to actually explain where they get all those periods from.
Well, it's in H1 dealing with the abuse.
It's H1. Yeah.
Oh, right, okay. Are they weekly? They're weekly periods, are they? Or monthly?
Because it makes it more difficult to follow what they're talking about, because they say by period 47 this had happened, but you don't actually immediately know what period 47 is. If they give a date,
yes.
we have this.
So the period where the tribunal in H2 says they had a choice, either resume supplies or exit the market.
Yeah.
That is defined by reference to a period. We know it's June 2014.
I mean, your case is, if you look at this chronology, it's perfectly plain that at different stages they were doing different things. To put it bluntly.
Yes.
Yeah. Okay. Thank you. I'm sorry. Sorry, Mr. Jowell.
I'm extremely grateful, and of course Mr. Brearley is much closer to the facts than I am, than my client is. And this brings me to another reason, a more general reason, why one can't, as I said, simply swap out the finding of an express agreement in 144A and put in a different kind of exchange or understanding that, and that is this, that when one takes the key basis for the CMA's case is this threat by Mr. Baton to enter if he wasn't given a supply timiously. Now that threat is not, as Ford has rightly explained, on any view an express commitment by him on the part of AMCO not to enter the market more extensive than the commitment in clause 2.2 of the second written agreement. And you've already heard from Ms. Ford why that can't be read into it, and we endorse those points. But and of course it wasn't put to the witnesses.
Well, that's the proper construction of the cross-examination point, really.
Yes, and it wasn't, but it also wasn't put to the witnesses in terms that this was a commitment going further than that in clause 2.2. So now, but my point for present purposes is simply this: that even if the threat did bear the extended meaning, this of entailing this additional commitment, even if it did, at most, then it would only do so within a wider commercial context. It doesn't naturally or obviously bear that meaning. If it bears that meaning, it does so because of the wider commercial context. And so, if one wants to interpret the threat in this way, one immediately gets into all of the points that Mr. Brearley and Mr. O'Donoghue have raised about the commercial context, about the factors, for example, whether one accepts Mr. Baton's evidence that he would never have given a commitment in return for these measly amounts, and one has to consider whether Mr. Patel would have only been likely to have offered this supply if he thought he was getting a commitment, or whether Mr. Patel could have done so purely as an incentive, which is not the CMA's case.
Well, and it's all mixed in, of course, with the commercial reality of Mr. Patel wanting Auden to be sold to
yes,
to MK.
Yes, indeed. It's mixed in with all of the other facts and all of the underlying documents and their entire chronology.
I mean, it's a hugely complex commercial situation.
Indeed, it is. And the threat is just, if you like, it's the tip of the iceberg, because you can't assess it in isolation of all of these other factors. And so that's why we say it's just not possible for this appellate tribunal to swap out the express agreement that the CAT found in H2 with a different agreement and say, hey, presto, it has to get entangled in all of the underlying issues and evidence.
I mean, I just put to you, Mr. Chow,
covered. Yes.
that one of the perhaps most unhelpful pieces of evidence that your side had to deal with, and I think this was put, was the cancellation of the Isaka contract and then the dealing with the staff.
Yes.
Now, I know we're not talking about Miss Lifton and her evidence that that they hadn't gone, that they'd gone slow.
Yes.
That's a different point from the actual cancellation of the contract for the time being, at the time of the pursuant, on the Saturday after the second written agreement. There are those emails that make it pretty clear that you've all done a hell of a lot of work getting this up and running and getting ready for us to enter the market, and now we're not going to do that.
Yes.
Now, I mean, I just wanted to put to you expressly, that sort of does sound like there's some reason for that.
Yes, the reason may be the practical realities combined with the second written agreement. I mean, the second written agreement itself says you can't provide your own product save on 3 months' notice. So
yes,
it
but
doesn't
it's not
entail,
really about 3 months, is it?
but it doesn't.
It's about, we've got to this point, we've got the commercial terms we want now. We're getting it for 172 a box. We wanted £1, we got 172, and now we've got 2 years' supply. I mean, that's what it reads like.
Well, again, it may
And
simply...
it's jolly profitable, brackets, 19.5 million quid.
Yes, but at most, that's one piece of circumstantial evidence that it doesn't directly
It
show
was
that
put.
somebody made a commitment.
Was put, and he agreed.
Well, I mean, I will leave it to others to deal with it. As I said,
Well, clearly
it wasn't our. Yes,
You've seen the cross-examination.
yes, but it's not. It just. I think that only goes to illustrate the point. One has to take into account much wider commercial considerations, and I think that it is difficult for this for this tribunal for this court to determine these matters without looking much more widely.
We didn't hear the cross-examination.
Indeed, and it may be it may be a unilateral decision. It may be the orphan designation. There may be a number of alternative explanations that need to be canvassed and explored and so on, much more broadly.
Yeah.
So those are that is why we say this this solution doesn't work. It's also not appropriate in my submission to if you like resurrect a judgment that is it's in terms provisional and has now been disclaimed by the tribunal below. It's disowned.
Unless, I mean, if we thought, leaving aside the point about going too far and findings of dishonesty, which the CMA weren't asking for,
Yes.
if the whole H3 process was completely and utterly flawed, and the putting the stamp on the top of each page was equally flawed, then why shouldn't we say, well, the H2 was the correct conclusion to have reached?
Because, my lord, the H2 has at its heart 144.8, and 144, the finding in 144.8 of a hidden or undocumented agreement, which included price fixing, expressly agreed, was simply never put to the witnesses.
Well, you say
how can
1.48 and dishonesty.
And dishonesty. But if one, in a sense, if one takes 144.8 and if one considers it and puts it next to Mr. Baton's evidence, he said there simply was no commitment.
Well,
And you put that next to 144.8, you can see one has some sympathy with the tribunal in saying that actually the finding it's made is very difficult to square without the witness being dishonest. It's actually not an unreasonable, if you put it in that way.
The point is, it's not relevant. Dishonesty isn't relevant.
No.
So why do you even get your head around it?
Well,
Because the moment someone says dishonesty, you're thinking, oh, there's that wretched Supreme Court judgment, Ivy, I've got to go through 2 stages. Or maybe I'm not thinking about that sort of dishonesty. Why even go there?
well, where it does come in is that whether one calls it dishonesty or not, it's misconduct. And if it's
Well, we don't need to go to
well, it is. It has implications for reputations. It has implications.
But that's a very good
It has
reason to
implications
just
for
stick to the law.
directors' disqualification. But the fundamental point, which I'm afraid one can't get away from, is that 144.8 makes a finding that was never put. It's the central finding, and it was never put to the witness, and that is, on the authority of Supreme Court authority of Griffiths and TUR, is unfair. So, unless you can swap that out and put in the threat, which was never considered in H2, and brings in all of these wider considerations, you can't. This new ground of appeal simply doesn't work.
No. I think we're going probably round in a bit of a circle. I mean, I think we get very clearly what you say, which is that this wasn't fairly put, that it's not a fair process. And you, companies, have not had a proper crack of the whip because of the way it was done. And whichever way you cut it, you say you can't just extract the bits you like.
No, my lord, that's it. And I'm very conscious I've gone over time. I want to very quickly, if I may, in 2 minutes, simply make the additional points that I want to make about the duration.
Oh yes,
The Allergan is in a sense in a slightly different position with to Actavis. It's one stage yet further removed from the actual infringement. It is the parent company of Actavis. It came in March 2015 and bought Actavis UK. Then subsequent to that, Actavis UK then in May buys Auden.
Sorry, just give me the dates.
Yes, so I'll give you the precise dates. So on the 17th of March 2015, Actavis PLC and Legacy Allergan merge. Then on the 29th of May, Actavis UK Holdings, so a subsidiary of...
29th
9th of May 2015, Actavis UK bought Auden Mackenzie, and with that, the shares in AM Pharma with Mr. Patel. Then as Ms. Ford pointed out, on the 1st of September 2015, the sale of hydrocortisone is taken over entirely by Actavis UK staff. So it's taken away from Auden Mackenzie altogether.
Say that again.
On the 1st of September 2015, the supply and sale of hydrocortisone is taken over entirely by Actavis UK. And so Allergan, its common ground, can only be liable if and to the extent that the shared unlawful common understanding persisted after May 2015. Because it's well established that the acquirer of an infringing entity will not be liable for that subsidiary's pre-acquisition infringement.
It persisted after May 2015, after the 29th of May.
Yes.
And you say it didn't?
Yes.
Because Patel had left on...
But on that day, on the 29th. And when one thinks about the nature of how it said the common understanding is arrived at in this case, in the case of the CAT finds this hidden agreement in 144.8. The CMA's case is a nod and a wink based upon the threat to enter. But either way, none of that is obvious to other people in the company.
Can I just put it to you this way? I know Lord Justice Green tried this earlier, but it strikes me as odd, as a sort of man in the street, that if there is an anti-competitive arrangement in place whereby a great deal of profit is being made by the parties to it, to the detriment, in this case, of the National Health Service.
Yeah.
And it's based upon a continuing 2-year agreement where the understanding is that they won't enter the market for those 2 years. And everybody's, if I can put it pejoratively, cleaning up, right? And one of the parties is taken over, and that party doesn't really bother to investigate and continues to clean up, putting it in the vernacular. Why does the fact that the understanding was made by somebody else, but is neither investigated nor changed, but you continue to cash the money, make a blind bit of difference to that anti-competitive arrangement? I mean, because you could be said to be responsible for looking at your arrangements when you buy a company to make sure that they are legal, due diligence and all that. And if you choose just to let something ride without inquiring, why are you not infected with the understanding that your predecessor put in place?
2 points. First of all, we called a witness, Mr. Stewart, and who was
Heard much about him.
who was involved in the responsible essentially for approving and overseeing the Auden acquisition. And his evidence, you'll see, perhaps given the time, if I can just give you the reference, it's in his witness statement, paragraphs 4.12 and 4.17, which is in the supplemental bundle, pages 93 to 94. And what he said, crucially, was, I haven't seen any evidence to indicate that those involved in acquiring Auden were aware or even considered the possibility that it was engaged in any anti-competitive agreement or conduct, or even that there was a risk that this might be the case. Now, he was tendered for cross-examination, he was cross-examined, but this part of his evidence was not challenged. So it was not challenged.
So why does that matter?
Well, the tribunal...
If it was.
Well, first of all, the tribunal found, as Ms. Ford has showed you, paragraph 137 of page 2, that no later acquirer, and that includes Allergan, can be criticised for failing to appreciate that there was an improper agreement between Auden and Amco. So there is a finding of the tribunal that no criticism is due to my client, Allergan, for not noticing this. And on that basis says that there's no intentional or negligent infringement by Allergan itself, as it were.
Well, that may be penalties.
Yeah.
Well, it does indeed go to penalties, and certainly to the any uplift on the fine for deterrence. That's this enormous uplift that was imposed. But in our submission, it goes further than that, because what the authorities say is that a new effectively if you wish to if you wish to stop an ongoing infringement,
Yeah.
you have to, they say, take steps to distance yourself from it. as it were. Now, if one thinks about an infringement of this nature, the essence of the infringement lies in a commitment that is given by one individual to another that is undocumented, that nobody else knows about, is said to know about, and was found to have known about. And how is one, and that individual leaves the company, how is a company in the position of Allergan supposed to distance itself? You can't distance yourself from an infringement if you don't know about it.
Then its fine is reduced.
Well, it's more than that in my submission. It's that it shows that in this...
But you're begging the a priori question, which whether the agreement subsists.
Yes, well, let me come on to that.
But the 137,
Yes,
you're absolutely right in what you say. They say
yes,
no intentional negligence.
yes.
But the last part of that, over the page, however, we do not consider these conclusions in any way relevant to the question of the intentional infringement of the prohibition by the later holders, because the acts and state of mind of Auden, because Auden is part of the same undertaking, are acts and state of mind of those entities also.
Yes. Well,
So that's the conclusion.
that's right.
That they reach.
And the fallacy in that is that Auden's, if that would be correct, if Auden continued to have in mind the crucial ingredient, that this commitment not to enter the market. But once Mr. Patel leaves, there's nobody in Auden that has that critical element in mind. Now, my Lord says, well, but everybody is still making money. But it's very common, of course, for infringements to end, but for the effects of the infringement to persist. There is very often in competition law, what one say where there is a cartel, there is then an overhang period where the prices remain high after the cartel ceases. Nevertheless, it takes some time for prices to drift down, and the infringer is liable for that later period, but not the subsequent purchaser that buys the company, takes over the company. The infringement ceases even if the effects of the infringement persist.
I think it's 1 o'clock.
And I think that's a good point, if I may conclude my submission. Content.
You don't need to conclude
No,
that.
I'm content to conclude.
Take my advice. Think about it over the agenda. You're bound to think of something that's burning you want to say.
You have 1.5 minutes after 2 o'clock.
My Lord, on that note, just very gently raise the question of overall timing.
Yes.
Because,
How long are you going to be?
well, they have used up all of their allocation of time,
Yes.
and
But we're
I
not going
have
to
got
hold
to respond to all of them with
Yes.
with Professor Bailey.
Yes.
There's quite a lot to get through.
Is that?
I had understood that now that they've run out of road, essentially, that would be it. But I think Mr. Brearley still has to come on again.
On market definition?
Yes,
Well,
and it's now putting us under unfair pressure.
Can I make a suggestion? Yeah. I've obviously been squeezed of time this morning because I thought I had half an hour. I've got just to respond to the CMA's ground 3, which is the involvement of Mr. Baton and Mr. McEwen, which I think the tribunal should be aware of. I can do that in 10 minutes. On object and market definition, what I would suggest is, in order to give Mr. Turner his time, I can, after we rise this afternoon, do a 4-page written submission on object and market definition. I can give it to Mr. Turner by 6:30 or whatever he's got tomorrow morning to look at it. Or I can do it orally, but...
Well, I think that's a very good solution, actually.
I do too.
You do your 4 pages.
Yeah.
I'm sure it's meat and drink to you, Mr. Brearley. You'll be able to get it out in 5 minutes, and Mr. Turner can then respond to it. You know that market definition to us looks like a bit of an uphill struggle.
Well, that's why. I mean, I did
Yeah.
want to spend some time on it, but it's a serious point.
No,
But
serious.
I would like to
Serious
just
case.
take the court to a couple of documents where we deal with Mr. McEwen, which I think...
Yeah, you say you want to deal with McEwen, that's fine. So Mr. Jowl will have 1 minute, you will have 10 minutes, Mr. Turner will make his do his best though.
It's the two of us.
Yes, we won't be able to sit late today, and tomorrow we'll be lucky to get back for 2 o'clock to start, but we will do our best. Unfortunately, we are in the hands of greater authorities.
Court rise, if you will.